Imagine you wake up tomorrow with nothing. No money, no home, no job, no food. Now imagine that in the country where you live, simply existing in that condition is against the law. Walking down the street without proof of employment, illegal. Eating a berry from a tree that grows on land you can see from your window, illegal. Wearing clothes that are considered too good for someone of your social class, illegal. Asking a stranger for food because your children are starving, illegal. This is not a dystopian fiction. This is not a thought experiment. This is medieval England. And today, we are going to count 7 real laws, written, enforced, and used to imprison, brand, and execute real people, that turn the simple condition of being poor into one of the most dangerous things a person could be. Stay with me, because by the end of this video, you are going to see something that I think will genuinely disturb you, not just because of what these laws did to people 800 years ago, but because of how familiar some of them are going to feel. Before the laws, before we get to the 7 laws, I need you to understand the world these laws were born into. Medieval England was a rigidly hierarchical society. At the very top sat the king and the great nobility, a tiny fraction of the population that owned the overwhelming majority of the land, and therefore controlled the overwhelming majority of everything that mattered. Below them, the lesser nobility. Below them, the clergy. And at the very bottom, working the land, building the buildings, growing the food, doing every form of physical labour that kept the entire structure functioning. The peasants. The peasants were not a minority. They were the vast majority of medieval England's population. Estimates suggest that somewhere between 75 and 90% of medieval English people lived and died as agricultural labourers, owing service and rent to lords who owned the land beneath their feet. And here is the fundamental tension that produced every law we are about to examine. The nobility needed the peasants to work, desperately. The entire economic structure of medieval England depended on cheap, controllable, abundant labour. But peasants, like all human beings, had their own interests, their own desires, their own capacity to move, to refuse, to demand better conditions, to simply walk away. The 7 laws we are about to examine were not accidents. They were not the arbitrary cruelties of individual tyrants. They were a system, deliberately constructed, carefully maintained, designed with one purpose above all others, to make sure that the people at the bottom stayed exactly where they were. Law 1. The Statute of Labourers, 1351. To understand the first law, you need to understand one of the greatest catastrophes in human history. Between 1347 and 1351, the Black Death swept through England with a ferocity that modern epidemiology still struggles to fully quantify. Conservative estimates suggest that between 1/3 and 1/2 of England's entire population died within a 4-year period. Let that number land for a moment. 1 in every 2 people dead. The social consequences were enormous and immediate. With so many labourers dead, the ones who survived suddenly had something they had never possessed before in any meaningful quantity: leverage. If half the workers are gone, and all the fields still need to be harvested, suddenly the workers who remain can ask for more money. They can demand better conditions. They can walk away from one lord and offer their labour to another who will pay them better. For the peasants of medieval England, the Black Death was, in the most terrible possible way, the closest thing to economic power they had ever experienced. The nobility's response was immediate, coordinated, and brutal. In 1351, King Edward III and his Parliament passed the Statute of Labourers. The law did several things simultaneously. It froze wages at pre-plague levels, the levels that existed before labour became scarce, before workers had any leverage. It made it illegal for a labourer to demand higher wages than those frozen rates. It made it illegal for an employer to offer higher wages. And critically, it made it illegal for a labourer to simply leave their current employer in search of better pay elsewhere. Workers were legally bound to work for whatever their lord was willing to pay them. Violation of the Statute of Labourers was a criminal offence, not a civil matter, not a contract dispute, a crime, punishable by imprisonment. The records of the years following 1351 show thousands of prosecutions under this law. Ordinary men and women dragged before courts for the crime of asking to be paid what their labour was actually worth in a free market. The law was not about order. It was not about fairness. It was, with breathtaking directness, about making sure that the economic catastrophe of the Black Death, which had briefly shifted power toward the poor, was reversed as rapidly and completely as possible. The rich had written a law that made it illegal for the poor to benefit from the one moment of leverage history had accidentally given them. Law 2. The Vagrancy Laws. The second law category is one that will feel uncomfortably familiar to anyone paying attention to modern debates about homelessness and public space. Vagrancy laws in medieval England made it a criminal offence to move through the country without authorisation, not to commit a crime while moving, not to cause harm or disturbance, simply to move. To walk from one place to another without the explicit permission of your lord, your employer, or a recognised authority. The logic of vagrancy law was directly connected to the Statute of Labourers. If workers could be prosecuted for leaving their employers to find better pay, those workers also needed to be prevented from physically moving through the country freely. A vagrant, the legal definition of which was essentially anyone travelling without documentation proving they had legitimate business and a home to return to, could be arrested on sight. In medieval England, the punishments escalated with each offence. First offence, public whipping. Second offence, branding on the ear with a hot iron. Third offence, for someone whose only crime was moving through England without papers, could mean execution as an incorrigible vagabond. What made these laws uniquely cruel was the category of people they primarily targeted. The genuinely dangerous traveller, the armed robber, the violent criminal, was rarely prosecuted under vagrancy law. He was prosecuted under other laws that addressed his actual crimes. Vagrancy law primarily caught the genuinely desperate, the widowed woman walking to a relative's home because she could no longer afford her rent, the labourer displaced by famine or flood, moving through the country in search of any work that would keep him alive, the discharged soldier returning from a war the Crown had sent him to fight, making his way home without the documentation that a legal traveller was supposed to carry. These were the people branded and whipped under vagrancy law. These were the people, in extreme cases, hanged for the crime of walking. Law 3, the Forest Laws. Of all 7 laws we are examining today, the Forest Laws are perhaps the ones that most clearly reveal the naked priorities of medieval English governance. The Forest Laws, which had their origins before the Norman conquest, but were dramatically expanded and intensified under the Norman kings after 1066, designated vast areas of England as royal forest. And within those areas, An extraordinary legal regime applied. Royal forest was not necessarily forest in the ecological sense. It was legal territory, land over which the Crown claimed exclusive hunting rights. And within that territory, the local population, people who had often lived and worked that land for generations, were legally prohibited from doing a remarkable range of things. They could not hunt, obviously. The deer and other game were the king's property, but they also could not cut down trees for firewood or building material without royal permission. They could not let their pigs forage for acorns in the forest. They could not clear land for agriculture. They could not, in many areas, even carry a bow through the forest. The possession of a hunting weapon in royal forest was itself a crime. And here is the detail that I want you to sit with. At the peak of the Norman forest law system, approximately 1/3 of England's total land area was designated as royal forest. 1/3 of the country where the rural poor, who depended on the land's natural resources for fuel, for food supplement, for basic survival, were legally forbidden from accessing those resources. The penalties for poaching in royal forest were, at various points in medieval English history, among the harshest in the legal code: blinding, castration, the removal of hands, death, for killing a deer, for feeding your family from a forest that stretched to the horizon in every direction around your village. The forest laws did not protect nature. They did not protect ecosystems. They protected the king's entertainment, his hunting, his pleasure. And they did so at the direct and often fatal expense of the rural poor who had nowhere else to turn. Law 4. The Sumptuary Laws. The fourth category of law is one that might seem, at first glance, almost trivial compared to what we have already discussed. But I want you to listen carefully, because the Sumptuary Laws reveal something about medieval English society that is deeply important. Sumptuary laws regulated what people were allowed to wear based on their social class. This is not a simplification. This is the literal content of these laws. Under various sumptuary laws passed by medieval English monarchs, most notably under Edward III and later under Edward IV, specific types of clothing, specific fabrics, specific colours, and specific accessories were legally restricted to specific social classes. Fur linings of certain types, restricted to the nobility. Specific colours of cloth, particularly scarlet and deep purple, restricted to the highest ranks. Gold and silver embroidery, forbidden to anyone below a certain income threshold. Even the length of a man's shoe, the fashionable pointed toe that was popular in the 14th century, was legally regulated based on social status. Noblemen could wear shoes with points of any length. Knights had a shorter maximum. Common people were not permitted the pointed style at all. A peasant who somehow acquired and wore clothing considered above their station was not just committing a fashion faux pas. They were committing a crime. But the sumptuary laws went further than clothing. They also regulated food, specific dishes, certain meats, certain preparations, certain numbers of courses at a meal, were legally restricted to the wealthy. The stated justification was social order, preventing confusion between the classes, making sure that everyone could be identified immediately by their appearance as belonging to the appropriate rung of the social hierarchy. The unstated purpose was something more fundamental: to make poverty visible, to ensure that the poor could not, even temporarily, escape the visible markers of their condition, to guarantee that the hierarchy was not just economic and legal, but permanently, inescapably legible on every body in every street. You could not dress above your station, and your station, the law reminded you every morning when you got dressed, was the bottom. Law 5. the gleaning restrictions. For thousands of years before medieval England, across multiple cultures and legal traditions, there existed a practice called gleaning. Gleaning was the right of the poor to enter harvested fields after the main harvest was complete and collect whatever grain, fruit or vegetables remained, the leftovers, the dropped stalks, the overlooked corners. It was, in many agricultural societies, considered a fundamental right of the destitute, a safety net woven into the fabric of the agricultural year. The Book of Ruth in the Bible describes gleaning as a divinely sanctioned right of the poor. In medieval England, that right was systematically dismantled. Landowners increasingly obtained legal restrictions on gleaning that either prohibited it entirely on their land or restricted it to such narrow conditions, specific times, specific people, requiring explicit permission from the landowner, that it became effectively inaccessible to those who needed it most. The courts upheld these restrictions. A poor woman entering a harvested field to collect dropped grain without the landowner's explicit permission could be prosecuted for trespass. Her meagre collection of leftover grain could be confiscated. She could be fined or imprisoned. The field had been harvested. The crop was gone. What remained on the ground would rot or be eaten by birds. But the legal right to collect it, the ancient, almost universally recognized right of the starving to eat what others had left behind, had been turned into a crime. The gleaning restrictions were not about protecting any meaningful economic interest of the landowner. They were about something more fundamental, establishing that even the leftovers, even the scraps, even the things that would otherwise be wasted, all of it belonged to the man who owned the land. None of it, by right, belonged to the people who were hungry. Law 6. The Debt Laws. Medieval English debt law operated on a principle that created one of the most vicious cycles in the history of poverty. If you owed money and could not pay, you could be imprisoned. And while you were in prison, you could not work. And because you could not work, you could not earn money. And because you could not earn money, you could not pay your debt. And therefore you remained in prison. Debtors' prisons in medieval England were not a last resort. They were a routine legal mechanism. A creditor, anyone to whom money was owed, could petition the court to have a debtor imprisoned until the debt was satisfied. The conditions in these prisons were, as we have already discussed in a previous video, catastrophic. Disease was endemic, food was minimal, death was common. And here is the element of this law that specifically targeted the poor with unique cruelty. Wealthy debtors had resources and social networks that could negotiate payment plans, secure sureties, and eventually satisfy their creditors. They had property that could be seized and sold. They had family members with enough resources to pay on their behalf. Poor debtors had none of these things. A wealthy merchant who owed money had options. A labourer who owed a small amount to his lord. Perhaps rent he could not pay after a bad harvest. Perhaps a fine he could not cover. Had almost none. He went to prison. He stayed until the debt was paid. And if no one on the outside could pay it for him, he sometimes stayed until he died. The law treated debt as a moral failure rather than an economic circumstance. And that moral framing fell infinitely harder on the people whose poverty made debt not a choice, but an inevitability. Law 7. The poor relief trap. The seventh and final law is perhaps the most insidious of all, because it came disguised as help. Medieval England did have a system of poor relief. Primarily operated through the church, it provided some degree of assistance, food, shelter, minimal medical care, to those deemed deserving of charity. But who was deemed deserving? The medieval poor relief system made a sharp and legally consequential distinction between two categories of poor people. The first category was the deserving poor, those whose poverty was considered to be through no fault of their own, the elderly, the severely disabled, the chronically ill, widows and orphans, people whose inability to support themselves was visibly, obviously and undeniably physical. These people could receive charity without legal consequence. The second category was the undeserving poor, those who were considered capable of working, but who were not working. The able-bodied unemployed. The person who was poor not from obvious physical incapacity, but from circumstances, economic disruption, displacement, the simple absence of available work. These people were not just denied poor relief, they were actively prosecuted. Seeking charity while being deemed capable of work was, under various local and eventually national legal frameworks, treated as a form of vagrancy. It was asking for something you were not legally entitled to receive. The trap was breathtaking in its completeness. If you were poor enough to need help, but not visibly broken enough to qualify as deserving, the system would not help you. And if you tried to get help anyway, if you asked a stranger for food or sought shelter from a church, you could be arrested for doing so. You were too healthy to receive charity, too poor to survive without it, and too powerless to do anything about either condition. Who built these laws, and why 7 laws? 7 different mechanisms, all pointing in the same direction. I want to be precise about something here, because precision matters. The people who wrote these laws were not cartoon villains. They were not sitting in dark rooms laughing about the suffering of the poor. Most of them believed genuinely that the social order they were defending was the correct one, that God had placed the nobility above the peasants for divine reasons. That hierarchy was not injustice. It was simply the way things were supposed to be. That belief made them capable of constructing a legal system of extraordinary cruelty without ever needing to feel cruel. The Statute of Labourers was not written by people who thought they were oppressing workers. It was written by people who thought they were restoring proper order after the chaos of the plague. The forest laws were not designed by people who enjoyed watching peasants starve. They were designed by people who considered the deer in those forests to be legitimately and obviously theirs, and who could not quite understand why anyone would question that. The sumptuary laws were not passed by people who wanted to humiliate the poor. They were passed by people who genuinely believed that social stability required visible hierarchy, that confusion between the classes was dangerous. And that is perhaps the most disturbing thing about all 7 of these laws. They did not require malice. They required something far more common and far more dangerous. The simple assumption that the way things are is the way things are supposed to be. 7 laws, the Statute of Labourers, that froze wages so the rich could rebuild their profits on the backs of plague survivors. The vagrancy laws, that made it a crime to walk through England without permission. The forest laws, that protected the king's hunting while peasants starved within sight of a forest full of food. The sumptuary laws that made poverty permanently visible and permanently inescapable. The gleaning restrictions that took even the scraps from the hands of the hungry. The debt laws that imprisoned the poor for being poor and kept them there until poverty killed them. And the poor relief trap that offered help with one hand and threatened arrest with the other. 7 laws, one purpose. Keep the bottom exactly where it is. Now here is the question I want you to sit with tonight.
How many of these 7
not about medieval England, about
how
right
many
now.
of these 7 mechanisms
How
do
many
you
of these 7
recognize
mechanisms?
from the world you are living
Wage
in today?
suppression, criminalisation of movement, restricted access to natural resources, visible markers of class enforced by law, debt traps, selective charity that punishes the wrong kind of poor, How many of those do you recognize from the world you're living in today? Leave your answer in the comments. Be specific. I read every single one. And if this video made you see something you cannot unsee, share it. History like this needs to travel. Hit subscribe, turn on the bell. Because next week, we go even deeper.